Welcome to the Deep Dive. We're here to cut through the noise and give you clear insights. Today, we're tackling something pretty serious, something nobody plans for, especially far from home. What happens if you're here in the US on a B1, B2 visa, maybe for tourism or business, and you get seriously ill? So ill, you can't leave before your stay runs out. It sounds incredibly stressful, right? But there are legal options. So our mission today is to kind of unpack those options, give you a clearer picture of how to handle this kind of medical emergency. Okay, let's unpack this.
Yeah, it's definitely a critical topic. You know, that B1, B2 visa, it's really meant for short trips. Business, tourism.
Right, temporary.
Exactly. Usually you get maybe up to 6 months. You might be able to extend it sometimes, but, well, getting seriously sick throws a huge wrench in the works.
Totally unexpected.
Completely. You plan for a short stay, and suddenly you physically can't leave. And like you said, it's not just inconvenient. If you don't handle it right, the legal fallout can be pretty significant.
Okay, let's talk about that fallout. Because I think some people might just assume, well, I'm sick, obviously they'll understand. But it's not automatic, is it?
No, definitely not. That's a risky assumption.
So what does it mean legally to be out of status in this kind of situation? And why is that term so serious?
Right. So out of status, that's basically the technical term for when someone on, say, a B1, B2 visa stays past the date they were authorized to leave, you know, the date on their I-94 form. Unless they've gotten an extension approved or have some other kind of protection in place, they fall out of status. And the consequences, well, they can really affect your ability to come back to the U.S. later.
How serious are we talking?
Pretty serious. Like, the moment you're out of status, your visa itself is automatically canceled. That's under Section 222G of the Immigration and Nationality Act.
Oh, okay. Automatic cancellation.
Yep. That specific visa becomes invalid right away. And then, depending on how long you overstay, well, that triggers travel bars.
Bars, as in you can't come back.
Exactly. If you overstay for more than 180 days but less than a full year, you're looking at a 3-year bar from re-entering the U.S.
3 years.
And if the overstay goes over a year, that jumps to a 10-year bar.
10 years, that's a huge chunk of time.
Uh-huh.
So these bars, do they just mean you wait it out, or is there a lasting impact even after the time's up?
That's a really important question. It's not just like serving time in detention, you know?
Yeah.
It becomes a permanent mark on your immigration record.
Permanent?
Yeah. Even after those 3 or 10 years are done, that period where you were here unlawfully, it's always going to be part of your history with U.S. immigration.
So future applications might be tougher.
Definitely tougher. Any future visa application, tourist, work, family, whatever, it'll get extra scrutiny. You'll likely have to work harder to convince them you should be allowed back in, prove you won't overstay again. It's like rebuilding trust, basically.
Okay. That sounds,
Yeah.
pretty severe.
Yeah.
But you mentioned something important. Does U.S. immigration law acknowledge these kinds of situations, like serious illness?
It does. And this is crucial. The law does recognize that sometimes there are compelling humanitarian reasons, like a sudden serious illness. There are specific ways to seek temporary relief. It's not a free pass, but pathways exist.
Okay, that's good to hear. It sounds incredibly overwhelming, especially if you're sick.
Yeah.
But knowing there are pathways,
Yeah.
that's key.
Yeah.
So let's shift to that. What can someone actually do if they're in this medical emergency? Especially if they're, say, still within their authorized stay or maybe just a little bit past it.
Right. Proactive steps are vital. And yes, it's definitely not a dead end, particularly if you act fast.
Okay, here's where it gets really interesting. What are the main options?
So the primary option, especially if you catch it early, is filing for an extension of stay. That's done using Form I-539.
Form I-539, got it.
Ideally, you need to file this before your current authorized stay expires, you know, before that I-94 date hits. Think of it like asking for permission before you overstay.
Makes sense, but what if someone gets sick suddenly, right near the deadline? Or maybe just after?
That's a good point. USCIS, that's the immigration agency. They can sometimes excuse a late filing, but only if the delay was due to extraordinary circumstances that were really beyond your control. A sudden, severe illness that literally prevented you from filing on time could potentially qualify, but you'd need strong proof.
So the golden rule is file before the I-94 expires, if at all possible. What kind of proof do you need for this medical extension? I'm guessing just a simple doctor's note isn't enough.
You're absolutely right. A generic note won't cut it. You need some pretty specific documentation.
Like what?
Okay, first, The most important thing is a detailed letter from a licensed U.S. doctor. This isn't just a note saying sick. It needs to explain the illness, the diagnosis, the treatment plan, and critically, it must clearly state why you are medically unable to travel. Is it the risk, the treatment schedule, contagion, air travel danger? The more specific, the better. Prognosis, expected recovery time, include it all.
It's very clear. What else besides the doctor's letter?
Second, you absolutely need proof you can support yourself financially during the extra time. Bank statements, maybe an affidavit of support from someone in the U.S. if they're helping. You have to show you won't need public assistance.
Right, that you can cover living costs and medical bills.
Exactly. And third, you need to show that your stay is still temporary. Remember, this isn't a way to stay here long term.
So, proof you intend to leave eventually.
Yes. Things like ties to your home country job letters, property deeds, family responsibilities back home, maybe even a return flight ticket booked for a future date once recovery is expected. It's all about showing temporary intent.
That's a lot of detail for the I-539. What about how long it takes to process? And, the big worry, what if your original stay expires while you're waiting for a decision?
Yeah, that's a common anxiety processing times. Well, they can vary a lot. Could be months, sometimes even over a year.
Wow.
But here's the good news. If you file that I-539 before your I-94 expires, you're generally considered to be in a period of authorized stay while it's pending.
Okay, that's huge.
Yeah.
So you're not racking up unlawful presence time.
Correct. During that pending period, you're typically okay, not accruing unlawful presence. Your visa usually isn't automatically canceled either. But, and this is important, if the application is eventually denied, then the unlawful presence clock starts ticking from the date your original I-94 expired. So a denial can put you back in a difficult spot.
And why might it get denied?
Could be several reasons. Maybe the medical evidence wasn't strong or specific enough. Maybe they weren't convinced about the financial support. Or sometimes if they suspect the person is just trying to use the illness as an excuse to stay longer without a real temporary intent.
Okay, that clarifies the extension route.
Yeah.
But what about the scenario where someone is already way past their authorized stay? Maybe they got sick, didn't know what to do, and now months have gone by. That sounds much riskier. Are there any options then?
It definitely gets trickier, no doubt, but not necessarily game over. If someone is significantly out of status, meaning their I-94 expired quite a while ago, filing an extension is usually not an option anymore.
So what then?
They might look into requesting something called deferred action, specifically on humanitarian grounds.
Deferred action. What exactly is that? Is it like getting a visa?
No, not really. It's crucial to understand. Deferred action is not legal status. It doesn't give you a green card or a visa.
So what does it do?
Think of it as like the government agreeing on a case-by-case basis not to pursue your removal or deportation for a temporary period because of your compelling humanitarian situation, in this case, the serious illness.
So it's protection from deportation, basically.
Yes, primarily. It's a form of prosecutorial discretion. It can prevent removal while the medical situation is ongoing. It might also allow access to emergency care and potentially keep doors open for other legal relief later, but it's temporary and doesn't fix the underlying status issue.
And it's discretionary, you said, meaning it's not guaranteed.
Exactly. It's entirely up to the agency, usually ICE or USCIS, whether to grant it based on the circumstances.
Given that, what kind of proof would you need? It sounds like you need a really compelling, sympathetic case.
You absolutely do. The documentation has to be rock solid. Very detailed medical reports, diagnosis from U.S. doctors, clear statements explaining why travel is medically dangerous or impossible right now.
Similar to the extension, but maybe even more emphasis on the danger.
Yes, and you need a very strong cover letter explaining the whole situation, the humanitarian need. Why your case is exceptional, you need to paint a full picture. The severity, the suddenness, lack of other options, the risk if forced to leave. They'll also look at your overall immigration history, ties back home, everything.
Wow, okay. So whether it's an extension or deferred action, this all sounds, well, incredibly complicated, especially if you're sick or maybe you're caring for someone who is.
It really is.
It just screams, get professional help, doesn't it?
Absolutely, 100%.
So what does this all mean? What's the biggest pitfall people fall into here, besides maybe just delaying getting that help?
You hit the nail on the head. Trying to navigate this alone or based on, advice from friends or the internet, that's a huge mistake. Immigration law, especially intersecting with medical issues and overstays, is complex. Each case is unique.
So find an expert.
Immediately. Find a qualified immigration attorney. Seriously. They can look at your specific facts, figure out the best path extension, deferred action, maybe something else entirely you haven't thought of.
Like what else?
Well, depending on the circumstances, maybe even things like asylum, though that's a very different process, or other humanitarian visas. An attorney can prepare the paperwork correctly, argue your case, and really try to minimize those long-term negative consequences, like the travel bars.
That makes perfect sense. Advocacy is key. Now, another critical point you touched on earlier. What if someone thinks, okay, this is too complicated, I'm just going to leave, get out before it gets worse? Bad idea.
Potentially a very bad idea. And this is something everyone needs to hear loud and clear.
Okay.
If you leave the U.S. while you have been unlawfully present even for 1 day over your authorized stay, you risk triggering those 3 or 10-year reentry bars the moment you depart.
Even if the reason you overstayed was because you were genuinely too sick to travel.
Yes. It sounds harsh and counterintuitive to many, but that's often how the law is applied. The act of departing while out of status can automatically trigger the bar, regardless of the underlying reason for the overstay.
Wow, so leaving could actually lock you out for years.
Precisely. So it is absolutely vital. I can't stress this enough. Do not leave the United States if you are out of status due to illness unless you've spoken with a qualified immigration attorney and they advise you that it's the best course of action in your specific case. Especially if you physically can't travel safely, an unadvised departure could slam the door shut on future U.S. travel.
That is such a critical piece of advice. It could save someone from a decade-long problem. Okay, one last scenario. What if someone did leave under those circumstances, or maybe they're outside the U.S. now, but need to come back urgently for life-saving treatment? Any options there?
There is one possibility, but it's quite rare and difficult to get. It's called humanitarian parole.
Humanitarian parole.
Yes. It allows someone who is otherwise inadmissible to enter the U.S. temporarily for urgent humanitarian reasons. This could potentially include needing critical medical treatment only available here, or maybe urgent family reunification in dire circumstances.
So you said it's rare.
Extremely rare. It's granted on a case-by-case basis, solely at the discretion of USCIS, usually for true life-or-death emergencies where there's no other way for the person to enter. The bar for approval is very, very high. You need overwhelming evidence. It's really a last resort, not a standard procedure.
Got it. A true emergency measure. Okay, so let's try and summarize this for everyone listening. It sounds like, yes, U.S. immigration rules about staying on time are strict. Very strict.
They are.
But there are provisions, sort of compassionate exceptions, built in for these kinds of really difficult medical emergencies. The key things seem to be act fast if you can.
Definitely.
Get all your documents in order, especially that detailed doctor's letter.
Crucial.
And, most importantly, get good legal advice right away. Don't try to wing it, and don't just leave without talking to a lawyer first.
That's exactly right. If we connect this to the bigger picture, look, nobody wants to get sick, especially in a foreign country. The stress is immense. But the main takeaway here should be, if this happens to you or someone you know on a B1, B2 visa, don't panic and assume it's hopeless.
Right.
There are established pathways to potentially stay legally until you can recover safely. But you absolutely have to be informed and take the correct steps. Understanding these options, getting that expert help, that's what makes the difference between a manageable situation and potentially devastating long-term consequences.
Wise words. Being informed and proactive is key. All the best, and we will meet again with another important matter again.